judgment in the appeals, the Queen on the application of Haney, Kaiyam, Massey and Robinson.
Lord Mance will explain the judgment of the Court.
The four appellants were convicted of various offences and received indeterminate prison sentences, either for life or for public protection, comprising firstly a fixed tariff period and secondly an indeterminate post-tariff period. Post-tariff detention was to continue until the appellants satisfied the parole board that they were no longer a danger to the public. The appellants, relying upon the decision of the European Court of Human Rights in James against the United Kingdom in 2012, claim that their post-tariff detention was unlawful because the Secretary of State failed to provide them with a reasonable opportunity to progress their rehabilitation and move towards release. Immediately the tariff period had expired. In James against the United Kingdom, the European Court of Human Rights found that a failure properly to progress prisoners towards post-tariff release breached their rights under Article 5.1 of the Convention, that is, their right to liberty, and it made their continued detention unlawful. The appellants claim that the Secretary of State failed them to provide them with a reasonable opportunity to progress their rehabilitation and release in these respects. Haney, relying on Article 5, that is the right to liberty, and 14, that relates to discrimination, claims that he was transferred to open prison conditions too close to the expiry of his tariff period to enable his immediate release upon the expiry of the tariff period. Kaiyam, Massey and Robinson, relying on Article 5, claimed that they were not able to commence particular rehabilitative treatment programs within a reasonable time of their tariff periods expiring. The Supreme Court unanimously allows Haney and Massey's appeal under Article 5, awarding Haney damages of £500 and Massey damages of £600. It unanimously dismisses Haney's Article 14 appeal and Kaiyam's Article 5 appeal. It dismisses the Article 5 appeal in the case of Robinson by a majority of 4-1, Lord Mance dissenting. Lord Mance and Lord Hughes give the unanimous judgment in the appeals of Haney, Kaiyam and Massey. Lord Hughes, with whom Lords Neuberger, Toulson and Hodge agree, give a separate lead judgment in the Robinson appeal. Lord Mance delivers a dissenting judgment. Lord Mance and Lord Hughes hold, first, the Supreme Court is not bound following the reasoning of the European Court of Human Rights in James against the United Kingdom. The European Court's reasoning that a failure properly to progress prisoners towards post-tariff release amounts to a breach of their Article 5.1 right to liberty should not be followed. Neither the express wording of Article 5.1 nor that of Article 5.4 creates any relevant duty to provide prisoners with a reasonable opportunity to progress their rehabilitation and release. Secondly, however, the overall scheme of Article 5 does impose an implied ancillary duty on the Secretary of State to facilitate prisoners' rehabilitation and release. Breach of that duty doesn't affect the lawfulness of the detention, but it does entitle prisoners, in appropriate cases, to damages. Thirdly, in respect of the appellants in the present case, Haney's delay in being transferred to open prison conditions deprived him, contrary to Article 5, of a reasonable opportunity to demonstrate that he was no longer a danger to the public, an opportunity which the Secretary of State himself had said that Haney should have. However, there was no breach of Article 14 in discriminating between pre- and post-tariff prisoners. Kaiyam's delay in being able to commence various rehabilitative treatment programs did not breach his Article 5 rights. He was provided with a reasonable opportunity to demonstrate that he was no longer a risk to the public through courses on enhanced thinking, drug awareness, and victim awareness, but his responses to those programs were poor. Massey's delay in not being able to commence an extended sexual offenders treatment program until nearly 3 years after the expiry of his tariff period and after the Secretary of State had provided for a timetable which was not in fact fulfilled, deprived Massey of the reasonable opportunity to demonstrate that he was no longer a danger in breach of Article 5. As to Robinson, the majority hold that Robinson's delay in not being able to commence an extended sexual offenders treatment program until nearly 9 months after the expiry of his tariff period did not breach his Article 5 rights. The question is not whether the appellant was deprived of access to a particular course, but whether he was given a reasonable opportunity to demonstrate that he was no longer a danger to the public. Lord Mance, dissenting, considers that Article 5 required that Robinson be given a reasonable degree of access to the extended sexual offenders treatment programme, which was not given him in the circumstances of the present case.
The court is now adjourned.